26 years of experience to abuse people in Alameda County and the San Francisco Bay Area from her office in Berkeley, California. She's a longtime member of the board of the East Bay La Raza Lawyers Association. Emily Rose Johns is an associate at Siegel, Yee, Bruner, and Mehta. She fights tirelessly for her clients and has amassed numerous victories in the area of prisoners' rights, police misconduct, discrimination in employment, education, athletic opportunities, and criminal defense. Emily Rose is a member of the National Lawyers Guild and serves on several local committees, including the Demonstrations Committee and the Next Gen Committee. She also serves on the legal committee of the Anti-Police Terror Project. With that, I'd like to turn to our presenters. As Daniel has noted in the chat, we will be taking questions after our presentation, or at least that was the plan. If Emily Rose want to change that up, they're certainly welcome to, especially in light of, I think, closer format. And with that, floor over to you.
Thank you, Rafael. And thank you all for joining us. I haven't conferred with Elena, but I'm happy to make this a more dynamic presentation in the sense that I'm happy to take questions as they come up for folks. Would that be okay, Elena, since this is—
Oh yeah, that's fine with me.
Great. But with that said, I'll at least do my best to set the stage for what happened in the Bay Area and kind of what is queued up for the needs of attorneys to come in and participate in criminal defense work or be criminal defense adjacent. And then, of course, an open invitation for anyone after this to contact me about participating in roles. Kyle, thinking of you specifically as an on-call attorney with the National Lawyers Guild as well. But as everybody who is participating in this call knows, George Floyd was murdered before our very eyes on May 25th, 2020 by a police officer in perhaps one of the most callous ways that we can imagine, just kneeling on him until he could not breathe any longer. It was a different kind of violence than I think we're used to seeing, sadly, seeing with some frequency in murders by police officers that are captured on video. And I think it came at a time where there was a tremendous amount of grief collectively brewing under the surface in the Bay Area and nationally. And as is customary in the Bay Area, people took to the streets beginning on May 29th, on that Friday. People took to the streets to express their collective grief, their collective anger. And as is fairly customary in Oakland, at least, you saw people gathering at Oscar Grant Plaza down in front of City Hall, marching in the streets of Oakland. And the police responded by using chemical weapons against individuals who were in the streets. They tear gassed crowds indiscriminately, used projectiles, shot people in the head. Individuals have lost, one individual that we know of lost sight in their eye as a result of being shot in the eye. There was a tremendous backlash from police, and so then day after day there were people coming to the streets and demanding justice and demanding that police be defunded, be held accountable in a manner in which they just traditionally have not been, and we've seen it over and over again in the Bay Area, where police officers in the Bay Area are murdering individuals using these levels of force, and as we've seen, police officers nationally do the same. As a result of this collective anger and grief, there were individuals who participated in some property destruction in the area, and the resulting arrests and resulting prosecutions, however, tell a story that we know very well, which is largely people of color and of the group of people of color who were arrested, largely Black folks being arrested, largely Black folks being prosecuted. And some of the statistics I can share from what the National Lawyers Guild collected are that 75% of the arrests were Black folks, 88% were Black and Latinx, and 94% are people of color, POC. Of the prosecutions in, and sorry, this is speaking specifically about Oakland, although this phenomenon is repeated in San Francisco, in Santa Rosa, in San Jose, where other people in those communities took to the streets. Of the prosecutions that we've seen in Alameda County, there were all but 10 of the individuals who were prosecuted in Alameda County so far were Black, all but 10. Individuals were picked up in a, for taking soap from a Walgreens in the middle of a pandemic, homeless individuals taking soap from a Walgreens and charged with commercial burglary and looting and all sorts of pretty heinous crimes that commercial burglary being a felony that can come with prison time. And so we saw as a result of this, not only indiscriminate force, racism plaguing the arrests that cops participated in, plaguing the prosecution. We've seen, and sorry, this is replicated, over and over again, but kind of in a major way right now because it's created a lot of attention as a result of George Floyd's particular murder that was captured on camera. But also just, I think, at a time where people are feeling generally like they need to put their money where their mouth is, right? Or put their time and effort where their mouth is. And so really appreciate having this kind of call and this kind of interest in order to further some of the goals that I have, that Elena has, the National Lawyers Guild has, and that BALIF has. I think, I don't need to speak for BALIF, but to see more equality under the law. People are still being charged with felonies and misdemeanors resulting from incidents beginning as far back as May 29th. And what we see in these cases where individuals are charged with a crime, a property crime, and they might be, they might not have even participated, right? There are other folks who've been arrested who were standing next to, and I keep using Walgreens as an example, but standing next to a place that appeared to have been broken into. Those individuals get picked up and arrested. And we're still seeing these charges come in, but what we see is if there's an individual who's charged with a crime, sometimes even if that disposition is favorable for that client, the charges are dismissed, or there's a disposition called a deferred entry of judgment, which we'll talk about a little bit, but that does not result in a conviction. People are still on the line for restitution. So even if Walgreens, again, to pick on them, is able to recover the majority of the stock that they may have lost through insurance payments, an individual might still be required to pay the entire amount of what that Walgreens calculated it lost. And that comes down very hard on individuals, who are caught up, who are, again, largely POC, largely living in poverty. In addition, the kind of comorbidity of the events that happened and the protests that happened in the last few months is that we've been living through a pandemic. And there were emergency, states of emergency that were passed at the local level and the state level that have been used, or we're starting to see them being used as punishment for individuals who, picked up a bar of soap from the Walgreens when the window was broken. That those individuals are being charged with looting for, or kind of in conjunction with these states of emergency that, stay-at-home orders and the like. Additionally, in this, I think it was for about 4 days, most cities in the Bay Area instituted a curfew, and there are still folks who are fighting charges for violating a curfew that they, in some instances violated as a result of police violence against them during demonstrations. So, for instance, there were folks who were gathered on a street prior to the imposition of the curfew, and then they were kettled, which is a term that means that police had gathered on all kind of areas of ingress or egress to corral individuals, and that folks were kettled and then not allowed to leave until after the curfew had set, and then they were out in violation of the curfew. So we're seeing these kinds of repressive tactics. They're not particularly new, but what is very new for us is that this is involving a lot more young folks in the Bay Area. It's involving a lot more leadership, I think, by folks of color, and at the same time, it's allowing us to discuss these tensions that continue to exist for folks in the Bay Area who are arrested and prosecuted, which is, and I'll repeat myself till I'm blue in the face, but which is that folks of color are targeted, folks experiencing poverty are targeted, and in this case, and in past protests, kind of more recently in Oakland, lots of folks experiencing homelessness are targeted. I'm sorry, that was a lot of information, again, some of which folks likely knew already, but to set the stage. But it's the reality that we are facing, and the sets the stage for some of the projects that we're going to talk about that we want to engage folks in at the end. Sets the stage for that discussion. So. With that, I'd like to turn it over to Elena to talk a little bit more in depth and maybe more collected about the criminal defense process, and then we'll come back and talk a little bit about how this all comes together for the work that you can do to help folks experiencing this repression.
Great, thank you so much. That was really informative. That was really helpful. Okay, so what I am here to do is to kind of explain to you all what the criminal process entails. So when people are getting arrested for looting, the difference between looting and a commercial burglary. So a commercial burglary is going into a place with the intent to steal something, and that place isn't a residence, it isn't a home. So that makes it a second-degree burglary. And the difference between a second-degree burglary and a looting is that that second-degree burglary occurs when there is an order, an emergency order, an evacuation order, or there's a state of emergency. And so that's the criteria that takes a regular second-degree burglary and bumps it up to looting. The other difference between a second-degree burglary and a looting is that a looting, if you are convicted of looting as a felony, you have a 6-month minimum for which you have to serve a sentence. A commercial burglary has no minimum. So, so there's a significant difference between walking into a Walgreens, because we'll just keep using Walgreens, walking into a Walgreens that's been busted into, realizing there's an opportunity there, taking some soap, and because you're unhoused, and coming out and then suffering a looting charge that has a 6-month minimum and potential restitution. I'll explain how that works. So what's happening is, as everybody knows, there is a number of courts and also in Alameda County where we've been shut down for a long time. There have been months where there hasn't been a whole lot that's going on and going forward. And so this has created a significant backlog in the courts. The statute of limitations for these cases, for the misdemeanors are a year, and for the felonies are 3 years. So right now, while we are suffering this backlog of cases, while they're trying to make up for all of those things that were set when there was a shutdown and everything that happened between now and then, you know, there is a chance that some of these cases may continue to be filed in the future. We just don't know. In thinking about, do I want to come in and participate? Do I want to do whatever training is necessary so that I can help, so that I can contribute to the defense of some of these folks? Just know you're taking on something that may not even get filed until the end of the year from when the protests occurred. And for some people, there is a potential for a couple of years and 3 on the outset. So think about that. Now, what is happening now, not clear on why, but what is happening now is nonviolent cases as a policy in San Francisco. Chesa Bodine said they're not filing any nonviolent cases, misdemeanor cases for the protests. They have left on the table to file for felonies and for violent offenses, and so those are assaults. So those things are still sort of on the table to be filed all over in Alameda County and in San Francisco County. If somebody comes to you and says, hey, I was out there, I got a citation, nobody's called me, my court date has come and gone, what do I do? Sometimes people think that if they have shown up to court on the date that's on their citation and nothing has been filed, then, you know, it was just a lucky day for them and they're out of it. But what's important to let them know is, depending on how it gets filed, whether it's filed as a misdemeanor or whether it's filed as a felony, there's still a whole lot of time that the district attorney has to file those cases. So what you want to do, if you're looking to sort of track this case for the person who comes to see you, you want to make sure you have their name, their date of birth. If they're in Alameda County, when you are arrested and booked, you get something that's called a CEN number, a CEN. And that number, the district attorney's office will have. And so you can call the DA's office and find out, hey, has this file come in from the police department yet? And has it made it to somebody's desk to consider filing? And kind of keep track of it that way. They will tell you whether or not the case has been logged in Alameda County, and they'll tell you if it's being considered for filing. They'll also tell you if it's been rejected for filing, and that's important for people to know. So that's sort of a kind of a low level help that you can give to somebody to find out just what's going on. It's stressful for people to have potential charges kind of hanging around, not knowing whether or not they're going to have to face criminal proceedings or not. So that's a nice way to kind of help people calm their nerves. In San Francisco, same thing, call the DA's office, name and date of birth, and they should be able to tell you whether the case is coming in. In Santa Clara, it's a little bit harder to get that kind of information when you call the DA's office. Sometimes they share it, sometimes they don't. It kind of depends on the clerk who answers the phone. If you know a DA in Santa Clara County, it's kind of helpful to call them and find out who it is to talk to, who's doing the charging, and you just talk directly to that DA to find out. Some of the things that you can do before a case has been filed is to start preparing the person that you're talking to about what they're going to need. You're going to want, if it's, these tend to be, not all the time, but you tend to get a lot of college students showing up at these protests. And so for those kids, as with most young people, don't think about future consequences. And so you're going to want to know from that person, are they, at the end of the day, when they finish their college education, do they plan on going into some sort of profession that's going to require that they be licensed? And if they do, that's important to know. So you know, if you're taking on the case, or if you're sending it on to someone, to be conscious of that, to be conscious of whether or not you have to be careful about something that's going to affect somebody's ability to be licensed down the road. You want to get background information about the person, whether they have prior offenses, either in California or somewhere else. You want to know if they, while they're waiting for cases to be charged, if they have people that they can get letters of reference from. You also want to know if there was any news footage that they might be in, so that you can preserve that. If there are friends whose cell phones took some video that might be helpful, you want to know that so you can preserve that. So all of these things you can start getting together now before, just in case you're waiting 1 year or 2 years down the road for something to be filed. You've preserved some things that will be helpful. But really only preserve things that are going to be helpful. There are a number of, one other thing. I mean, there is some thought that maybe some of these cases might not get filed until, you know, people aren't paying attention anymore. But there seems to always be a new reason for people to be out on the streets protesting police violence. So I don't know that that day is going to come. There's another issue when people are talking to you about coming to you because they might have a case, and what you want to be conscious of and aware of. Candace, you know probably better than anybody in the room, and those are immigration consequences. Some of these offenses, depending on how they're charged, if they're crimes of violence, if there is a restitution order of over $10,000, some of those things can affect or just the nature of the offense, can trigger immigration consequences. So if you have somebody here who may be on a student visa, or if you have someone here on a work visa, or who may be here for a variety of reasons, then you want to have that information so that you know what the implications of any conviction may be. Also what the implications of, after being arrested, the implications of leaving the country between now and when the case is resolved, if it gets filed. So you want to make sure that if you have that information, and if you have that information, to consult with an immigration attorney so you know you can best advise the person that you're talking to. So briefly, the criminal process, it doesn't sound like there's many folks on here that do criminal defense. And so I'm just going to go over just a general outline of how the criminal process works. So once the case goes from the police department to the DA's office, they make a decision about filing. Depending on the county, depends on what they do. If somebody got a citation and they have a court date that's out there a bit, or they had a court date that came and went and nothing was charged and something is charged later, it really depends on the county on how they handle that. In Contra Costa County, oftentimes they'll put the case on for an arraignment. Sometimes in Alameda County, they'll put the case on for arraignment, and the person will never really know that the case came on, a bench warrant is issued, and then the next time they happen to be out and come in contact with the police, they could be arrested. The charge may have been filed within that statute of limitations, but the person may not have been picked up for quite some time. That happens a lot with our unhoused clients, where you know, it's not until there is some police contact that they realize there was a case and they didn't realize they had one. So if you have some early contact, it's a really good idea to just check periodically to see if anything, if it's made it to the DA, and if it has, if there's been a decision. And then there's also about a couple of month lag from when a decision is being made to when it gets to the clerk's office, filed, and a court date is given. So if it's a felony, for a felony, there are two parts to a felony litigation. There is the first half, And in that first half is where you have the arraignment. And at the arraignment, you discuss things such as, release as the case is pending, whether or not there are any issues to raise for the filing. It's really important to know if you are, and Emily Rose will talk about this, if you're thinking of taking on one of these cases, that you get some, connect with someone who has done these sorts of cases before. There are a number of issues that can be raised in a demur. And much like I think a civil demur, that has to be done before a plea is entered. So you don't want to show up in court and enter a plea of not guilty and then figure out that there may have been some issue that could have been raised on a demur. So, the arraignment happens, then there's you get some of the discovery, there are discussions with the DA about resolving the case, and then there's a preliminary hearing, which is a probable cause hearing. So before anybody can be made to face felony charges, possibly, have the risk of going to trial and risk prison, because felonies, the difference between a felony and misdemeanors, felonies you can go to prison, misdemeanors you cannot. Of going to prison, there has to be this probable cause showing through this hearing. And that is, the district attorney has to show the judge that a felony has been committed and not a misdemeanor, and that the person sitting there is the person more likely than not that committed that offense. So they have to make that showing. It's a probable cause level of proof. But if you can't show both of those things, then that can't move forward as a felony. So whatever is shown in that probable cause hearing, whatever offenses are proven by probable cause, are then put in a new charging document called an information. And 15 days from the date of the preliminary hearing, there's an information that's filed, and those are the charges, if you're going to trial on a felony, that you're going to be facing as a felony. So it is, felonies tend to be lengthy processes unless you are going on a no time waiver basis. And that means that you have a right to have a speedy trial. For a felony, you have a right to have a preliminary hearing within 10 days of entering your plea. Once you have an arraignment on the information after a preliminary hearing, you have a right to have a trial within 60 days. So it can go as slow or fast as appropriate for each case. For a misdemeanor, you don't have that first half of the process. The maximum sentence on a misdemeanor is a year, and there is no probable cause hearing like a preliminary hearing. You have a right to have a trial within 30 days if you assert your speedy trial rights. And so in the process, you are having discussions with the DA, getting all of the evidence, figuring out what the defense is, and sort of proceeding through the case. When somebody is convicted and then sentenced on any of these cases, there is a requirement. The judge has to order restitution, and restitution is any financial loss that a victim suffers as a result of criminal wrongdoing. And that the definition of victim over time has expanded. The definition of, who is affected by the criminal wrongdoing has expanded over time. And so that's an area where you want to spend a lot of time figuring out what, if any, financial responsibility your client may have. And that's what Emily Rose was talking about. She'll talk a little bit more about that. If you're part of something bigger, if you are somehow brought in to a bigger scheme, you could be responsible for the whole rather than the bar of soap that you're holding on to. And so those are really important issues that need some research now. And Emily will talk about that. And again, what we are seeing is that the offenses that are being charged are looting and assaults for the most part now in Alameda County. I think they're similar in San Francisco, and Emily will know that a little bit better about the about that. So what are you going to look at for defending these cases? For some of these cases, there are First Amendment grounds that may be raised. For others, whether or not they were, a participant, or whether it was someone who just kind of, took advantage of this situation, stepped in, grabbed something, and ran. Do you have to be part of the whole? Do you have to be part of the group that went in, that actually busted the glass to get in the store? So all of those issues are issues that should be litigated. And the other one is whether or not the stay-at-home order is an emergency order as it's stated in the statute. So the health, the pandemic health order for everyone to stay at home, is that an emergency order? There have been other times in our history where emergency orders have been issued. And so the question is going to become, is the stay-at-home order one of those? And if it's not, then it's just a simple second-degree burglary and not looting. And then your client doesn't risk a mandatory minimum of 6 months in jail. So that is kind of an overview of the criminal process. Sorry if it was too fast, but if you have any questions, let me know. I can explain it a little bit differently, but we're going to go back to Emily, and she's going to explain some of the research issues that people could use some help with.
Great, thank you. And I see some of the questions in the chat. I know we have a moderator, but I think that at least one of these topics is going to address one of the questions regarding what a DA has to prove regarding the kind of relationship between the declared emergency and the activity that occurred, the alleged looting. So there are a couple of research projects that folks who, and the reason we kind of thought about this and thought about presenting it to this group is that, folks who are interested in learning about criminal defense issues, but don't have either the experience or desire to really step into a courtroom on behalf of a person who's accused of a crime. This is an area that you can help with that will have, what's the term? There's a phrase I'm looking for, but we'll have a benefit well beyond your participation just in the research, right? There's some issues that we're trying to research or trying to get into our brief banks regarding looting and then regarding restitution, because as Elena had mentioned, there are circumstances where an individual who simply, was found with, again, bar soap. I use that because it's one of the most inflammatory things that I've seen in doing this work, is charging somebody who's unhoused for taking, allegedly taking a bar of soap from a place that had already had their windows broken, right? The commercial establishment that had already had their windows broken, in a state of emergency where things like soap and hand sanitizer have been hard for people who are, resourced to come by. So I find it very inflammatory, continue to mention it. Don't mean to sound like a broken record. However, those folks could sometimes find themselves in situations where they're put on the line for the entire loss that a business has suffered. And again, that loss can even be, Elena might know this better than me, but the loss can even be a loss for which they were compensated through some insurance coverage, so that they don't actually have an out-of-pocket loss, but the out-of-pocket cost can be placed upon somebody who is charged with the crime of looting. And so one of the questions that we have is let me just, to help folks ground themselves in the crime of looting, it says, every person who violates section 459 of the penal code, which is, if I'm not mistaken, is the burglary penal code section. I'm looking
Right.
for Elena to,
Yeah.
to nod at me. Punishable as a second-degree burglary pursuant to another subdivision, sorry, during and within an affected county in a state of emergency or a local emergency or under an evacuation order. And then the penal code goes on, but it doesn't explain what that state of emergency needs to be. And to give you an example of how this can, this can kind of stretch the bounds of logic. Currently in Oakland, and for the last maybe 5 years, there has been a state of local emergency that's been declared. It's a state of local emergency regarding shelter. That Oakland does not have enough shelter for individuals experiencing homelessness, and therefore there is a local state of emergency. Now, if somebody commits a commercial burglary, while that local state of emergency exists, have they committed looting? So the idea, logic would dictate, is that there has to be some relationship between the state of emergency that's declared and the action that is that a person's being accused of. It can't be that just because the city of Oakland has declared a shelter emergency that anybody who commits a crime is committing a crime during a state of emergency. But we haven't seen how that bears out either in a, is there a due process argument that we could be making on behalf of folks who've been charged with looting regarding the, specific state of emergency that was in effect while this charge was lodged against them? Or are there specific examples? Does the state of emergency have to be declared under a specific government code? There are several government codes for different kinds of states of emergencies, a specific government code. These are questions that would be helpful to have extensive research on so that we can crop from that research in doing, motions practice on behalf of clients who've been charged with looting. And so, again, some of the questions, and we can brainstorm as we sit here as well, and as we, hopefully can continue this conversation beyond this presentation. Some of the questions are, what is the definition of state of emergency under the Penal Code section 463A? Does the public health crisis qualify as a state of emergency? And then is the statute so vague or overbroad that it prohibits otherwise protected conduct under the First Amendment? And so that's and that would be, I think, specifically for the for our curfew that was initiated in the several different counties. And so those are questions that we haven't fully researched and haven't fully answered that are going to be helpful for the cases that are currently charged and the cases that are going to be charged down the line. I think Elena made an astute observation, which is Nancy O'Malley, the DA in Alameda County, has been the DA for a long time, and she's not stupid. It's at least around, when it comes to the way that she charges crimes, right? She, I think, is thoughtful about waiting perhaps until there's less focus and less uproar about what has been going on nationally with respect to police violence, but also maybe even until the pandemic is over and people have kind of returned to their everyday lives. And I think it's 3 years is the statute of limitations for these felonies. I'm looking at Elena today.
Right.
Yeah, 3 years. So anybody who the police picked up, and the police picked up a lot of folks, in addition to picking up a lot of folks, because the state of emergency that was declared resulted in the Bay Area counties saying that people could not be held in jail for crimes that were not of a certain list. And I think looting was one of the crimes for which they could be held in jail despite the pandemic. But a lot of other crimes, the Judicial Council said you couldn't hold individuals in jail. You had to put them, you know, on a $0 bail and release them. And so police officers, instead of taking people to jail, took pictures of people's IDs and took some notes with them and then left. And those people could possibly receive summons at a later time as a result of the police going back and writing up reports and figuring out what they want to charge, or what they want to have people charged with, sending them to the DA. The DA can sit on them again for, you know, for certain felonies, and the felonies I think we're largely dealing with here for 3 years. And so this work is going to be important not only right now, but going forward as we start seeing more cases. And like I said, cases are still being charged today for back in March. And I think they will, you know, we'll continue to see this as especially as the DA's office ramps up its capacity, and as more and more offices are ramping up their capacity despite the pandemic. Another issue, and you might, Elena, I'm sorry, do you mind if I talk about the restitution issue too?
Oh, no, please.
Okay.
Yeah.
So another issue that we need help with is figuring out what the limits on restitution can and should be in these situations where folks are charged with looting or you know, commercial burglary, so that one individual, you know, an unhoused individual who takes a bar of soap is not on the line for the, you know, thousands and thousands and hundreds of thousands of property damage that has been that folks have experienced. You know, we see restitution is not an order that the district attorney, or excuse me, it's not a crime that the district attorney needs to prove beyond a reasonable doubt. It has a lower burden of proof on the district attorney, and you have a separate. Sorry.
Can I just jump in here and explain real quick about restitution just for a second, just so you guys know? So restitution is one of those things where, unlike an actual criminal charge, where the burden is on the prosecution to prove beyond a reasonable doubt that the crime was committed, when it comes to restitution, the burden is on the defendant to show that whatever claim was made by the victim isn't appropriate under the law. So the burden shifts to the defendant to show that they're not responsible for whatever claim that was that the victim made. So sorry to interrupt, Emily, but I just want to give just sort of a brief overview of restitution. And you cannot negotiate restitution as part of a resolution. It was part of the victim's Bill of Rights, and so a judge has no discretion other than to order restitution in a case. So sorry to interrupt. I'll give it back to you, Emily.
No, thank you. I appreciate that, and I think, you know, in the spirit of this being a discussion, that's very helpful. And so, you know, some of the questions that we have around restitution is, can the court order restitution for more than the value of the merchandise possessed by the defendant at the time of arrest? And we think we know the answer is yes, right? We've seen it happen. But if there are, if there's research and cases out there that folks wanted to put together to help argue against that, and again, either on, you know, on whatever grounds is available, due process grounds, on Eighth Amendment, you know, unreasonable fines, fees, and restitution grounds, right? All of that. We're looking for creative solutions and creative arguments for these issues. Another question is, can an individual defendant be ordered to pay restitution to a commercial establishment for the damage to the building? Especially if they, you know, it's clear from all of the evidence that they came to the store later. So for example, can somebody who sees a broken window, goes in and grabs an item from that place and then is caught, be charged with the cost of repairing the window? And, you know, looking for other cases and how that are similar to these cases here and how they've been decided. And then, of course, I said this already, but the Eighth Amendment, you know, there's an Eighth Amendment angle to whether or not restitution that's ordered for, again, you know, the entire Walgreens, when it, you know, you've only gone in and taken a bar. So whether that would be an excessive fine under the Eighth Amendment, whether there's any protections there for folks, and how you raise that, right? Is it raised at the restitution hearing, or does an order for restitution have to be issued, and then you can appeal that based on its excessiveness? And so these are some questions that we would love help answering. And like I said, they would have, you know, returns for years and years to come, because we do think that these cases are going to be charged over the course of the next, you know, year at least, if not longer. And we are, you know, I hate to say it, but we're undoubtedly going to see this again. This is not a unique dynamic in the Bay Area. It is not a unique, these are not unique questions, but we have a lot of manpower, woman power, people power right now to answer these questions and to do extensive research on it, and to get good briefs that we can share with the attorneys who are doing the work as well. And then want to encourage you to become the attorneys who do the work. But we can definitely talk about that, that ask and how you get involved at the end. I do see a list of questions in the chat. I don't know if we want to move to those, or if you wanted to say something more, Elena. I've been looking at them and I'm interested in answering them if we want to be moderated into them.
We can move on to the questions. Good.
Yeah. So Raphael, do you want us to just start answering these questions, or do you want to moderate the questions?
Under the sort of smaller group setting that we're in, I think it's safe for you all to just ask and answer the questions. I don't necessarily think that, like a larger crowd, it would make much sense to moderate, but I'm happy to ask them for you if you like.
I think we're fine. Sorry, I think we're fine. I just didn't want to disenfranchise you.
Thank you for that. One myself about statutes of limitations. I know that the statute of limitations for certain civil cases were paused for at least a period of time thanks to the COVID crisis. And I'm wondering if the same applied to any of these citations or other criminal offenses.
I haven't seen anything that indicates, I haven't seen anything that indicates that there has been any order that tolls the statute of limitations during this time.
Yeah, I agree. I didn't, and I did a quick search to reassure myself, but courts were operational for criminal cases to some degree, right? You could still file a complaint in a criminal case, which was distinct than how they were operating with respect to civil cases. And so there, I don't believe, was any tolling that would benefit the charging parties, the district attorneys. And then, Elena, I want to ask you this question. So Danielle had asked if there's any requirement that the prosecution prove that a charge of looting based on a declared emergency was motivated or facilitated by conditions arising from the emergency.
That's not in the statute. And what's in the statute is, you know, it's a looting is a second-degree burglary. So all that's required to prove for looting versus a second-degree burglary is that it occurred. The issue of the nexus, I think, is what Emily Rose was talking about earlier. That's some of the research that I think we're looking for people to do, because to raise those issues of whether or not there has to be some connection between whatever the state of emergency is and the event that's going on, the looting that's going on. So this was a health state of emergency. Does that then make this a looting?
Got it. Thank you so much. I just want to add, and hopefully invite other participants to also chime in if they ask a question and want to follow up. But I asked this question because through BALIF's participation in the California Conference and Bar Associations, the delegation, the body of delegations actually voted to pass a resolution requiring that there be a nexus. So I already knew the answer to it, but I wanted to highlight it for everybody else as something that's an important thing to have there. So if we all see this resolution become a bill, I hope that everybody will follow it along and try to support it. But essentially, this issue is being identified by others across the state as something that, as you said, just has to be proved that it existed, not that it was in relation to, right?
Thank you. That's helpful. And could you put more information about that in the chat so that we can follow up? I'd be interested in that resolution. Thank you. And then I'm going to skip over your next question, Daniel. Come back to it. But so Katie asked if we're seeing rioting charges in the Bay Area and charges for conspiracy or protest organizations are being charged as conspirators. And I'll say a little bit of what I've seen. I'm not sure if you have a different experience, Elena, but I've not seen rioting charges here in my practice since I've been here in the same way that they were in DC or other jurisdictions where they were charging people with like felony rioting. The DAs, the local DAs have not seemed to have an appetite for that and for those charges. And I'm not even sure what, there is a misdemeanor riot in the penal code, but I don't even know if there's felony riot or what riot, what would need to happen for it to become a felony charge. As a general rule, we haven't seen a lot of misdemeanors charged right now. And it's for a number of reasons, including that the courts, I think, have informally, if not with some formality that has not been communicated to me, not held arraignments for misdemeanors. So they're prioritizing holding arraignments for in custody felonies. They just started in Alameda County, at least, holding arraignments for out of custody felonies. Before that, they'd been charged, but then they just kept pushing back the arraignment. And so the charges that we're seeing largely are the looting charges and assault on an officer or assault with a deadly weapon, because police officers in the Bay Area are upset that people have thrown plastic bottles at them while they're wearing riot gear and attacking protesters with tear gas. And so the result is that they've started doing a lot of these charges for assault on a police officer or assault with a deadly weapon. We haven't seen conspiracy charges, certainly not of protest organizations, but even so far have not seen conspiracy charges for groups of individuals who are accused of, conspiring to commit any of the offenses. California is a unique jurisdiction, and I think only one of a handful of states where folks can be charged with felony conspiracy to commit a misdemeanor. I think most states, you can only be charged with misdemeanor conspiracy to commit misdemeanors or felony conspiracy to commit felonies, but California is cheeky in that way. And we have seen that in the past, but usually, in my experience, where I have seen conspiracy charges as a repression tactic has been for very specific kinds of civil disobedience, or even when it's not, kind of traditional civil disobedience, something that might kind of lend itself to more clear conspiracy charges, a group of people who really did execute a plan over time rather than using them as a repression tactic for protest organizations who are having folks, for instance, the Anti-Police Terror Project, right? Having folks go out and they did an F your curfew protest on the last night of, I think it was the last night of the curfew, in defiance of such a, oppressive and vague law. and we haven't seen anything like come out of that. That's not to say that we're not going to, or that one of the things that we are thoughtful of is whether or not the federal government is going to take an interest in the Bay Area in similar ways that they have in other jurisdictions on the West Coast. And so I think we always think that there is more to come, and we want to be thoughtful about that. I talked a lot, sorry.
No, that was great information.
Yeah. So Elena, I'm going to ask you, another question was, can you speak a bit about how the judges in our counties are likely to skew on these issues if they come before the judges in Alameda County, San Francisco County? Do you have a sense?
I don't. I think that there was just a recent rotation of all the judges, so it's hard to know. It's hard to, I mean, I don't think that the judges have sort of one thought one way or the other, or that is, you know, that you can tell. These cases are going to Oakland and then out to Dublin, so I don't have an answer for that. It's hard to know.
Yeah, and I'm sorry.
I can't be more specific.
I mean to pick on you. I will say, you know, I can't say, you know, universally, right, how judges are handling this. I think what we've seen in some of the preliminary hearings on felony cases that have gone forward is that the judges are taking this very seriously, and there is not, at least so far, there doesn't seem to be an appetite to view this in a whole context and in a whole picture. Whether or not that's something that we want judges to do, right, to take information from the outside and let that influence their opinion. I'll let everybody come to their own conclusion about that. But we have not, I think, you know, what we've seen is folks being held to the information on felony charges for looting and having some pretty fierce statements from the bench about their distaste for the crimes that folks have been alleged to have committed. I'll also say that in my experience, although I haven't been in court on a assault on an officer case out of this particular set of protests, in my experience, those, you know, it's not unique that the police are seeking to prosecute folks for you know, things like throwing bottles or throwing rocks. Although I don't know where they keep talking about rocks. I haven't seen any rocks. I don't know where you get rocks to throw at police officers in the Bay Area, but of course the police are very vocal about that being a real problem for them when they're monitoring protests or and in those cases, it's not the judges and the seriousness of the offense when you're dealing with judges. It's the district attorneys who have started to feel like they have a duty to protect protect the police, protect the institution, and have really, there's a few district attorneys who deal with these cases that I've seen who really taken that mantle. And that's a problem, right? If the DA is particularly hard-lined about these things, it becomes, whether a judge wants to be lenient or not, you know, or understanding or not, however the judge is feeling, it becomes harder for your client if you have such hard lines from the DA.
I'm really curious about sort of some trends. I know that we tend to be very lucky in San Francisco in that we've just elected a progressive prosecutor, you know, like the definition of a progressive prosecutor. So when you mentioned, you know, prosecutors becoming more aggressive and taking a stance that is more like protecting the institution, can you tell us where do you see that? Are there trends? Are there certain counties over others? I
mean, Alameda County. I actually have no experience in Santa Clara County. I don't know, Elena. I don't mean to force you to adopt my analysis either, but I'm wondering if you have any experience that you can share from Santa Clara County. And then,
I would just say generally, you know, what you find when you, because over the years, as particularly in the protest cases, we get these charges of assaulting a police officer. You know, even with the tree sitters, you know, with Julia Butterfly Hill, my guy was handing her water and the water spilled on the cop and he got charged with assaulting an officer. And so not just arrested, but charged. So it, you know, it happens in what, and some of you who do plaintiffs work and civil rights work will know better than I. But what I have, my understanding has been is that when your client either pleads to something little or stipulates to probable cause, that creates some barriers to that person making a civil rights claim against the police. And so if any of you do civil rights law and know that and want to chime in and answer that affirmatively, but that's been my understanding. And so what happens is you get these charges of assaulting a police officer, either as misdemeanors or felonies, and then you get an offer for a dismissal with, you know, a stipulated and probable cause, and we had that for years. I think Alameda County stopped doing that a little bit back, which was really nice. But not so in some of the other counties. Santa Clara County is just a more conservative county across the board than Alameda County. Same with Contra Costa County, although it's getting a little bit better with Diana Becton. But yeah, I mean, the unions are strong. And so there, you know, there are affirmative steps taken to protect the officers.
yeah, I do civil rights, so I can chime in too about what you were describing, but that is something that's important to be thoughtful about if you are going to take on a criminal defense case, and you are going to be asked, even, you know, when you take a plea even for a lesser charge, you have to, you know, stipulate to a factual basis for the charge. And if you know, I haven't seen this play out exactly, but I think if you stipulate to the factual basis based on the police report rather than on, for instance, your own investigation, I have a practice of saying so stipulated based on my investigation, then that the facts in the police report can be used against your client in a civil rights case to what's called provide a heck bar. Heck is the name of the case that's terrible, but a heck bar to litigation or to liability for the officer. So for example, if an officer used excessive force against you, your client, not you, used excessive force against your client during an arrest, and your client pleads no contest to a resisting arrest charge, which is a misdemeanor in California, and oftentimes is what things plead down to. They plead to resisting arrest and they stipulate to the factual basis in the police report, then they can be barred from saying that there were other facts that meant that the police officer used excessive force, and they can their claim can fail in court as a result of that bar. In addition, if you stipulate to probable cause for the arrest, you no longer have a false arrest claim, because probable cause is the defense to false arrest. And unfortunately now, because of the Supreme Court in this jurisdiction, it's also a defense to a retaliatory arrest. So it's charming. So Kyle, I see your question, and I think we're going to talk a little bit about that at the end. There was one question that I intentionally skipped for the end. And then there's another. So one question from Daniel is, what happens when you refuse to follow police orders? And have we seen people charged for very vague things like resisting arrest? And do you want to talk about that statute, Elena? Resisting.
Oh, the resisting and not following a police officer's order. Yeah, I mean, that's the sort of catch-all, right? The many things that are considered resisting or not following a police officer's order, including an order to disperse or, an order to move aside, in order to sit down, whatever that order may have been. Those are, we tend to be able to get rid of those offenses easier. Oftentimes, if that's the only offense, I saw another question, if I can leapfrog onto that about diversion programs for defendants. Diversion is available, and deferred entry of judgment is available for most misdemeanor offenses. And so for those of you who don't know, diversion, a diversion program is where you do something, some sort of a class, depending on how small the offense is, some kind of a class, some kind of training, and your case is sort of, you waive your time to a speedy trial, your case is moved out for a bit, you come back and show you've done whatever you're supposed to do, whether it be community service, a class, or whatever, and then the case is dismissed. And you will never have had a conviction. A deferred entry of judgment, what that means is you agree to admit to some offense. It's oftentimes a lesser offense, but you agree to admit to some offense. You enter a plea of no contest, which is saying, I'm not fighting this, but I'm not saying that I'm guilty, I'm just not getting in the fray. And then you are not sentenced in that moment. You give up your right to be sentenced for misdemeanors. It's within six hours or 5 days. You give up that right to be sentenced right away, and your case is put over sometimes for a year. You don't get in any trouble again. You don't get arrested again. You do whatever classes you have to take. Sometimes it's anger management. Sometimes it's doing community service. And then if you've had no arrests, when you come back on that year, your entry of a plea of guilty or no contest is withdrawn, and then the case is dismissed. So you will never have had a conviction. That works for misdemeanors, it works for felonies. It does not work if you are a person who could suffer immigration consequences, or if you're a person who has a professional license. A DEOJ, when you enter that plea, is considered a conviction for immigration purposes, when normally in the state of California, a conviction does not occur until you are sentenced. But for immigration purposes, for federal purposes, a conviction occurs when the person enters a plea. And so that's why you have to know, is this person got some immigration concerns? Are they going to be, do they want to sell real estate in the future? Do they want to be a teacher in the future? Any of those issues that may come up, that entry of a plea is considered a conviction for those purposes as well. So sorry, I kind of went off the rails there. Go ahead.
Yeah.
Back to you, Emily.
No, and I want to follow up on that with two other thoughts, and I appreciate that. It's really thoughtful about professional licensure. I oftentimes, I deal with that on an ad hoc basis, but lots of your clients in criminal defense cases will have some kind of professional licensure, and you want to always be thinking about that when you're thinking about any of these kinds of dispositions. Deferred entry of judgment is a term that I'm most familiar with in Alameda County, but you can also get dispositions such as, what am I thinking? Deferral of, sorry, Elena, it totally, deferred prosecution. Excuse me. I was like, tell me what I'm thinking. You can get a deferred prosecution. And deferred prosecution is somewhat similar, except for with the deferred entry of judgment, as Elena described, you say, you plead no contest, and then they do not sentence you. And then when you come back at the specified time and you've, obeyed all laws, state of good conduct, and you've done the community service or the anger management course or whatever you need to do, your plea is withdrawn and the case is dismissed. A deferred prosecution puts a pause on the case right away, and then you do the things that you're supposed to do, and you come back in the allotted time, and if you've done the things, the case just gets dismissed without the requirement that you make some kind of plea with no execution of the sentence. With a DEOJ, those can be fairly dangerous for clients who are likely to be arrested again or likely to have police contact. So you want to think about whether your client is experiencing homelessness, and people experiencing homelessness have police contacts all the time because they're on the streets, and at least the Oakland Police Department has nothing better to do with their time apparently. If your clients are people of color and they're living in East Oakland, I have clients who, regardless of whether they're doing everything right or even, the same kind of wrong things that I did today, like jaywalking, right, have frequent police contacts. And so those can be very dangerous for those clients if they have frequent police contacts, because any arrest could result in the execution of the sentence without any further process under a DEOJ. And so I try to press for, if we can, deferred prosecutions, because then the only thing that happens, the only consequence is you're back to where you paused, right? And then you have to go through the prosecution. Of course, they don't love those in the DA's office. I don't know if it's, I don't know why, but definitely DEOJs are preferred. They feel like they have a lot more kind of control or consequence associated with that. In San Francisco, there are very formal procedures. There's pre-plea diversion, there's pre-charge diversion, there's pre-trial diversion, and all of them are programmatic. They have like an office. The office will assign you to a specific place to do your community service hours or your anger management course. Excuse me. And so those are more formal, and I think some other jurisdictions have things that are more formal. But in Alameda County, it's nice because it's fairly fluid, like you can craft it, it's fairly fluid. And so one of the things that we do with protest cases, we had a young woman who was charged, and we did we did deferred prosecution, and she went and worked for Quilombo for her community service hours. And Quilombo was a very radical group of folks who did some really incredible work that she really believed in and aligned with. And so it was a nice way to kind of give back to the community in the same way that she, felt like she was by being in the streets and by decrying this, horrific police violence that we've all been experiencing either as individuals or likely through video and through the media. But it was a nice way to kind of further that. So I'm a big fan of deferred prosecutions if you can get them. So I think it might be the questions I'm seeing now, and unless I've skipped somebody's question, and please speak up, are more questions about how you can get involved. And so this might be a good time, especially since we've been talking for about an hour and a half, a good time to talk about the ways to follow up and the ways to get involved. Am I? Okay. I'm seeing thumbs up. I'm seeing. So as Elena and I have talked about, we do work with the National Lawyers Guild. I'm a board member with the National Lawyers Guild, and I'm also a part of the demonstrations committee. And so if you're an attorney, I think everybody on here was an attorney. I apologize if I'm skipping any legal workers. The National Lawyers Guild welcomes legal workers as well, just obviously not to perform these specific roles that I'm about to describe. But if you are interested in becoming a member of the National Lawyers Guild and becoming a member of the local demonstrations committee, you can do work with mentorship. So some more experienced criminal defense attorney will mentor you through your first cases and your first projects, or your, the first 5 projects, if that's what you would like. And we will help you, we can assign you to a misdemeanor case if you feel comfortable with that, and assign you to, we have infractions that we defend folks on as well. Lots of protesters get infractions. In fact, I think a lot of the curfew violations, if they're charged in Oakland, which I don't actually, I think Nancy O'Malley said she wasn't going to charge them unless it was in conjunction with something else. Like maybe you would have a curfew violation if you were also charged with looting at, you know, after hours. But those would be charged otherwise as infractions, and then we do demurs on infractions. We fight on behalf of folks who have infractions, because those go to traffic court where you aren't provided with a public defender. And so those kinds of cases are great ways to start as well. And the way to do that, and I'll put it in the chat when I'm done blabbering, is you go to the nlgsf.org, and you can express your interest in you know, joining the National Lawyers Guild and joining the demonstrations committee, and we can make those connections for you. There's also a role within, like on the night of demonstrations, called on-call attorney. So if you're working with the demonstrations committee, you can be an on-call attorney for that night. And what that generally entails, although it's changed in the time of COVID, but what that generally entails is being willing and able to drive out to Santa Rita and meet with individuals who are confined in Santa Rita, and who might be appearing in court in the next 2 days. And we need to find out information from them, like, do you want bail posted for you? Who is the person who can co-sign for you? Sometimes that can be done through our hotline, but sometimes we need an attorney to go out. And the reason an attorney has to go is because, at least in Santa Rita, and it might be the same in San Francisco, but in Alameda County and Santa Rita, only an attorney can come in to visit a person before that person is formally charged and confined to the jail pending their trial. If a person is after their arraignment, the person can say, oh, I want these people to be my family members and whatnot to be able to come visit me. But otherwise, you need a bar card in order to visit somebody. And so we go out and we do the work to work up a bail motion that an attorney can make. And you might be the on-call attorney that goes out and does that, and then also appears for their arraignment in court in the next 2 days, especially. That's been especially true as we've had, fewer and fewer attorneys who are willing and able to do the work, and it's good and important work, and it helps lessen the impact of incarceration on people's lives, especially if there are cases where the DA decides that they're not going to charge folks, but they're still stuck in jail for several days and they have no contact with anybody, and it can be really oppressive. So that the on-call attorney role with the National Lawyers Guild used to kind of traditionally fill that role. Now it's a little bit more fluid because it's a lot of advocating for people to be released on zero bail because they don't meet the bail schedule, and just being generally available on the night of a demonstration in order to answer those questions and do that kind of advocacy, and then also appear in court for arraignments for folks. With misdemeanors in Alameda County, you can make a special appearance on behalf of individuals who are present. So you ask the person who's arrested to be present, and you go in with them, and you can make a special appearance to do their arraignment or put it over for attorney and plea. And that way you're not saying you're the attorney of record, but you're doing that that labor for that person so that they don't have to appear in their first court appearance alone. And then we can talk about whether or not you want to take the case or somebody else should take the case, or how that works. And so that's a lot to say. Visit the National Lawyers Guild and let them know that you want to be a part of the demonstrations work, and the National Lawyers Guild will plug you in those ways. And then
a good way to get involved in some of the research projects that you mentioned as well.
That's what I was going to add. That's what I was going to say. So the research projects, we've actually we discussed this in the National Lawyers Guild, presenting that specifically to the folks who wanted to participate in this call and in this project. And so I think we didn't talk specifically about how we wanted to follow up about that, but what I think would make sense, Elena, tell me if I'm wrong, is if we put our emails in the chat as well, and then you can contact us if you're interested in working on that, working on those research projects. Would that make sense, Elena?
Yeah, it does.
Okay, and then we can be the, you know, the connection between you and the National Lawyers Guild, but also you and, you know, the Public Defender's Office has expressed interest in, you know, hearing about the results of this research as well. And so I think, you know, you're not just, it's not, like I said, labor just on behalf of the National Lawyers Guild or labor just on behalf of me and Elena, although, you know, I welcome that too. Right? But it, you know, it's work that we're hoping to have a collective impact and important anti-repression work.
Well, that's fantastic. On behalf of BALIF and everyone who's attended and all of the people who are out there on the streets and who need this representation, thank you so much. Really wonderful presentation.
Thanks for hearing us. Appreciate it.
We are at actually just after our 7 o'clock finish time. We really appreciate it. We're going to leave the Zoom up for a couple more minutes so that everyone can get the information available in the chat now, so that you can follow up if you'd like to. And yeah, thank you again so much. Fantastic presentation, much appreciated. Obviously very timely and important.
Thank you. I appreciate you all. I put in the National Lawyers Guild, the local chapter website. Go look on there. You can become a member. There's a sliding scale. If becoming a member does not make sense to you, but you still would like to help, just email me and we can talk about it. Or still like to do that on-call attorney role. And that invitation is for everyone, but I'll also call you out, Kyle, specifically because you mentioned it. Please do contact me if you would like to talk more about getting involved and mentorship on that. I appreciate the involvement that you've had previously and would like to make sure we keep everybody engaged.
And Katie, I'm curious as to where we left the holes.
Oh yeah, I'd love to talk with you more too. I went to law school in DC and was in DC for Occupy, so.
Yeah, I'd love to stay on for a few minutes if you're available.
Yeah, maybe we could, if it makes sense, whoever is controlling this, maybe